This court recognizes the importance of Article 50 of the Constitution, that an accused person should be presumed innocent until proved guilty. The accused person should be released on bail or bond whenever possible. Those are the words found from the bail and bond policy guidelines. Opposition to granting of bail is not a violation of that right. That is why the Constitution uses the words unless there are compelling reasons. That puts a duty on the prosecution to place before the court any evidence they may have on compelling reasons for consideration by the court. It is the prosecution which has the onus and the burden to prove the presence of compelling reasons to deny bail. It is also the reason the victims are given an opportunity to be heard before bail is considered, and a mention made of the requirement for victim impact statement in the Criminal Procedure Code. Indeed, in this application, the victims were represented by counsel, and they did make submissions at the bail hearing to argue then that any opposition to a release of an accused person on bail is a violation of that right is erroneous. On the issue of dignity, this one was raised by Mr. Ombeta and a response by Mr. Ondari. I want to say that I do not wish to define the word dignity. However, I think it has nothing to do with what Mr. Ombeta urged or what Mr. Ondari thought it could mean. Dignity has to do with the treatment of an accused, not his status. The binding constitutional principle of right to equal treatment before the law abides here. There cannot be equal treatment before the law based on the status or lack of it of an accused person. I look at dignity in terms that are set out under the International Convention of Civic and Political Rights that was quoted by none other than Mr. Ombija, the lead counsel for the accused. That instrument provides that accused persons shall, save in exceptional circumstances, be segregated from convicted persons and shall be subject to a separate treatment appropriate to their status as unconvicted persons. Having stated that, I just wish to state that the segregation referred to here does not mean that it can only be realized by the release of the accused from the remand. It means the physical segregation within the place of detention, and so far no complaint has been raised in that regard. And I have said that if it is raised, it can be dealt with at any stage during the proceedings. Now, on the issue of complexity and the strength of the prosecution case, I have noted that the prosecution is here to provide witness statements, documentary and other evidence they intend to rely on at the trial. Now, failure to provide them cannot be interpreted to mean that the prosecution has no case at all unless good grounds exist which could lead to such a conclusion. On the issue of capital charge and the issue of right to bail, now on this issue, the seriousness of a charge and severity of the sentence to be meted out is a major consideration on the issues of bail. It is, however, considered alongside other factors and cannot, standing on its own, be a ground to deny bail. On the investigations still being underway, I've said investigations are still underway, cannot be wished away, and it is evident given the fact that other persons have subsequently been brought before this court facing the same charge. On the issue of the status of the accused person and likely to influence the case, I'll say that when a person is elected as a leader or representative, he or she commands a lot of power, both within the confines of the particular area they represent and also even outside of it. There are measures the court can apply to ensure such power does not affect the case, for instance, by imposing strict terms. Now, the likelihood of interference with investigations, witnesses, threats, and intimidations. The nature of the case has been changing, and more additional persons are being brought, charged before the court with the same offense. Interference with the case is not just constructive by meddling with witnesses or with the case. It can also be affected indirectly, say by the releasing of some of the persons facing the same charge while others are being arrested. Now, on the issue of confessions, I've said the issue of confession is a matter for trial, and that is not, and it is not before this court. And then the issue of the safety of the co-accused, which was also raised, is not a matter before the court, and the court cannot decide at this stage, as there are no co-accused in the information which is before the court in this case. On public interest, order, and security, I'll say that the issue of public safety and security is a matter that the parties in this case cannot comment on for lack of material to form a basis for an argument either way. Now, the only material before the court is the affidavit by Inspector Mwangi. It contains averments that security may be destabilized. The court is, however, aware of threat to security in the area the offense took place, and that is what informed the arraignment of the accused person here in Nairobi. So security is an issue. However, at this stage, I find it difficult to draw a conclusive finding at this stage. Now, the conclusion is that the application cannot be determined before the witness statements and other evidence are availed to all the parties. That is the only way that this court can fully exercise its discretion, applying the factors for consideration in determining whether or not any compelling reason exists to deny bail. So at this stage, I'm disallowing the application.